everybody, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. In the next couple of minutes, we're going to answer the question of why you may want to avoid probate. Before we get there, however, if you have any questions about this topic or anything estate planning and probate related, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Now, most folks hear that maybe I should avoid probate. The question is why? So, first and foremost, your last will and testament, when it gets presented to the court, is subject to a whole bunch of rules. And that's based on law in your state. Well, those rules, of course, because they have to be followed to the T, are restrictive of your family's flexibility in dealing with your matters after your passing. For example, where I practice, there is a requirement that before your will is even really reviewed for the details that you've subscribed, a consent is required from each of the individuals they would define as your heirs at law. Your heirs at law are essentially any individuals related to you who would receive if you had no plan. And what that consent requires is them saying that they're okay with the person you designated under your will to act as your executor. Of course, if you don't get consent from one of those people, then there could be a hearing and extra steps, time, money wasted. The second reason I think is important to point out is that there is a mandatory creditor period. Now, in some states, as I understand it, is longer than others. Some states require a formal, public notice so that creditors see that. And in the states where I practice, while no public notice is mandatory, they're provided with 7-8 months worth of time to file a claim against your estate. During that time, your family is just kind of hanging out and waiting to distribute assets, even though they're doing other things relative to your estate. It sort of puts a restriction on them overall. Again, just following the rules. And thirdly, your record, your last will and testament, does become public to anyone. So if you had, say, a disinherited child, you had an ex-spouse, you had a disgruntled family member who thought you were going to leave them something, when that document, your last will and testament, gets presented to the court, mind you, it hasn't been validated yet, anyone who sees that that record has been submitted and can review it has the chance to argue against it. This is not so much the case with a trust, a revocable living trust, where someone, while they can always fight it, it's a lot less common because it is a private document. And folks may be restricted, if they're not a designated beneficiary, to even obtain that information whatsoever. And it insulates your wishes a little bit better. As a reminder, if you have any questions about estate planning or probate, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Thank you so much for listening. And if you like this information, please share, like, and subscribe where appropriate so you and others don't miss out. Again, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to estate planning, through estate planning, elder law, and probate matters. Thanks again. Have a good one.